It's recording to. Yeah. There's no session.
No.
Okay, commissioners, we're ready to go when you are.
He just saw me, he didn't see me in my
Yeah.
session, so. Yeah,
It's my space.
yes, enjoy that.
Ready? Yep, go ahead.
Okay. Welcome to the North Logan Planning Commission meetings, May 4th, 2023. Happy to see people here. We will have Heron will lead us in the pledge and Gavin will give us a prayer to start out.
All right, repeat after me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Our dear Father in heaven, we give you gratitude that we reside in this free country in the state of Utah and in North Logan. We are grateful for the freedoms that we enjoy. We ask thy blessing upon us tonight, that we will keep in mind the rights and privileges of all the residents of the town, and that we will do right by them. And we say this in the name of our Savior, Jesus Christ. Amen.
Amen.
Thank you, Heron and Gavin. We'd like to excuse Kenny. He's still out of town. But we're glad the rest of you are here, Board. It's good to see you. We need a motion to adopt the agenda. Do I have a motion?
Madam Chairman, I move we adopt the agenda as presented.
Do we have a second? I second. Right, it's been moved by Heron and second by Heather that we adopt the agenda for tonight's meeting. All in favor? Aye.
Aye.
Any opposed? Okay, it's adopted. Thank you. We don't have any minutes to pass this time. So we'll move on to follow-up issues from a previous meeting. Scott?
Yeah, just a couple of quick updates. So last night, City Council considered a couple of items that were before the Planning Commission in times past. So you guys may or may not remember the Chris Clarkson subdivision. It was also called Green Canyon Grove subdivision. It is now finally called Canyon Grove subdivision. It's on 4th East and I think it's like 1750 North, kind of catty corner to Meadowview. That was a 6-lot subdivision that came before you last summer, and the last 8 to 12 months the developer was looking at ways to provide secondary water to that subdivision. Ultimately he landed on using a private well, so he'll be drilling a well and that well will be operated and maintained privately by the HOA. So that was on the commission agenda or the council agenda yesterday for their preliminary plat and development plan approval. You guys have given them a positive recommendation last summer with the condition that he figure out that secondary water component. And then having done that, that's where that project is now. So it'll move forward to a final plat and construction documents phase of review before it finally records, but that's moving forward.
So do they have to have the well done before all the final reports?
Yeah, so they'll need to get that dropped. He's already working on getting a drill start card, and those things will be moving forward. There's good water in that area, so we're not too concerned about him finding water, but that's the plan, at least for secondary water.
Scott, question, is that the one that they had the 6 lots, they were going to develop half of them first and then half later, or is that?
No, this was almost a year ago, so it might be a little bit fuzzy in your memory. This
It is.
was all in one phase. It's on a private lane with a hammerhead turnaround,
Okay.
all private. So that'll be a private lane owned and managed by the HOA.
Okay, I think I remember it now.
Yep. So that one was approved last night. And then also you'll remember at our last meeting, I believe this is the one you're probably thinking about, Commissioner Hoyt, the Linden Lane subdivision. That was 8 lots, but it was separated north and south by 3100 north. That was a concept plan that we looked at last meeting. That was approved for concept by the city council last night as well. So that one will move forward to preliminary plat development plan for your review here in the next couple of weeks when they get that submitted to us. It'll undergo an initial review internally with staff and our engineer and public works and internal review agencies. But that will be back on your agenda probably next month sometime for preliminary plat. And then lastly, the commission or the council reviewed the connectivity text amendment that we've been working on as far as the terminal streets, permanent versus temporary terminal streets, and how do we connect those streets on the master plan? And then how do we incentivize superior connectivity? So that was reviewed by them. They did make one change before they approved it. They wanted to simply cap that street network at 30 homes, no more. As you'll recall, we had a provision in there that if they wanted to go beyond 30 homes, they potentially could, but they'd have to fire sprinkler all of those additional homes. The council decided, let's just cap it at 30. So we'll make a quick revision to those red lines and then that ordinance will be signed. Okay, so that's the only other follow-up item from the last meeting and last couple of meetings, actually.
Okay. Thanks, Scott. All right, we'll go on to agenda item number 1. Election of a planning commission vice chair, the remaining of the year. So we just need a nomination of somebody. That's not me.
You don't
'Cause I'm
want to
already
do both
this.
roles? Come on, man. She could do it. I would like to nominate Kenny Reese as the vice chair.
I talked to Kenny and he said if he got nominated, that would be okay with him, even though he's not here.
Because I nominated him last time when he wasn't here. And he,
Any other
any
nominations?
other nominations?
All right, I guess we're ready for a vote. All in favor of,
No, we did not.
No,
he what?
We
I'll
didn't get a second.
second.
Oh, yeah, we need a second. Gavin. So Heather nominated and Gavin seconded Kenny Reese to fill the position of vice chair. We all in favor?
hi,
Any opposed? All right. It'll be Kenny.
Very good.
He'll be thrilled. He won't leave town ever again. Okay, let's go on to item agenda number 2. Scott, you want to start this out for us, please?
Yep. So this particular agenda item is back before the planning commission. This is a past conditional use permit that we had reviewed a couple months back now. It's the first conditional use permit of 2023. So the file number is CUP 2023-01. This is for a detached accessory dwelling unit in the R1 zone. And upon review, Planning Commission made a motion to deny that conditional use permit with the idea that it would be too big to meet the standards in the code. However, that particular action by the Planning Commission was appealed to our appeals hearing officer, who, when reviewing recent case law, Utah case law, indicated that there needs to be specific written findings of fact, conclusions of law to support an administrative action by the Land Use Authority, which is the Planning Commission on conditional use permits for North Logan City. So ultimately, that decision was remanded back to the Planning Commission for additional discussion and additional findings of fact, written findings of fact, conclusions of law added into the formal record, which would then allow for the appeals hearing officer to conduct a more thorough review of that decision by the commission. So we've put it back on the agenda. We've already held a public hearing as part of the original discussion on this, so there's no need to rehold another public hearing. This is a public meeting. We do have the original applicant here with us, and we'd like to make sure he has a chance to address any of the discussion tonight to protect his due process, to address the evidence that we may discuss and the discussion that the commission may have. Okay. You'll notice that in your meeting packet, I had provided you with some notes on this topic, some of the code that was discussed during the original discussion, some terminology that needed perhaps some clarification. And ultimately, what the commission will need to do tonight is to rediscuss the facts, identify findings, determine any interpretations of the law and make formal conclusions that we can then write into the record. Now you can use that set of notes that I provided you as a springboard. If you agree with them, great. That will give us an opportunity to write up a more formal notice of decision with those identified topics included. If you have additional thoughts, I know some of the commission has reviewed that and maybe have some other thoughts they'd like to add in. But we'll go ahead and open up that discussion and get down to brass tacks and get those written findings established. Okay.
Okay. Anybody have any thoughts they want to start out with? I think everybody was here except Gavin, right? When we discussed this the first time.
Correct.
Do you have questions?
Yeah,
concerns?
so I spent a good bit of time reading through this in the original application or the original item from the 2nd of February. And so the evidence interpretations of law document that we have in front of us, this notes, I think it's well written. I do have one concern. I don't know if we've got everything we need in there. So Scott, I did write up a comments and put it into the same folder. I don't know if you.
I did, yeah. Let me pull that up right now.
So as I read through this, the decisions of appeal hearing officers stated in the last paragraph of section 3 that the findings weren't sufficiently detailed in this instance because it does not disclose how the planning commission arrived at the conclusion that the accessory dwelling unit is built entirely over the garage. And so that was a specific item that the appeal officer called out. And the municipal code also says if an accessory dwelling unit is built entirely over a garage. And then in the findings of fact, we say that we find that the dwelling unit is proposed to be located entirely over a detached garage. What I couldn't find is any evidence in this document that points that out specifically. Then the closest thing I could find was under the evidence section. It says based on the applicant's explanation, and then it begins to explain. And so I think we might be a little deficient on the evidence that shows that it's entirely over. And so so what I did is, if you scroll down to the bottom here, these are two things we could consider. One, you could say something along the lines of, based upon the construction photos, there's a garage on the main floor and there's a dwelling unit above. If you wanted to get a little more detailed, you could use these and say that the exhibit B from the application shows that there's the floor plan shows no stairs between 1 and 2. So they are two separate spaces. And then the next thing we could say is that from the construction photos, there appears to be no other entrance to the first floor other than the garage doors. Therefore, by plain meaning, that's a garage. And everything above it is separate and totally above it. So I think we need to find some way to add in here that the dwelling unit or the detached
Accessory dwelling.
the detached accessory dwelling unit is built entirely over a garage. We might need to add something of a fact or some way that we know that that is specifically true.
Yeah, and so are you indicating that you believe that there is evidence to support the fact that they are not associated with each other? The detached accessory dwelling unit does not have direct access to that garage below.
Yeah, and the reason I wrote that is, yes, that's my belief from what I was able to read in the public record from this documents and last time.
Okay.
But the reason I brought that up is that what if there were living space on the first floor? Then there will be living space that isn't directly above a garage.
Mhm.
And so from everything I can see, all of the living space is above a garage by those two things.
I'm wondering if it would be beneficial to go ahead and just read through those notes real quick, just for the benefit of those in the audience and also for the commission as we are looking at this. So we can see, as we're referencing the notes section that I provided you, that we're all on the same page. Does that sound maybe like a
That's a
good
good idea.
way about going about it? Let's do that. Okay, so I've put this together just as a summary for us to reference. Let me blow this up so everybody can see it here. So a couple of things that I pulled out of the original application as in addition to county and city records that were available. So the apartment floor plan sketch as submitted by the applicant depicts a dwelling area of 38 feet wide and 39 feet deep for a total apartment area of 1482 square feet. Photographic evidence through the Cache County Assessor's Office indicates that the detached accessory building was built in the 2015 to 2016 timeframe, and that the 1,482 square foot apartment occupies the eastern portion of the detached accessory building's upper level square footage. Cache County Assessor's Office records indicate that the overall square footage of the detached accessory building is 6,400 square feet with 3,200 square feet on each of the two levels. And based on the applicant's explanation, the detached accessory building includes a garage space on the lower level, which is intended to be used by the primary single-family dwelling. A portion of the upper level would be used as a detached accessory dwelling unit, the 1,482 square feet. The remaining portion of the upper level has historically been used as a dance studio, but is currently being used as storage space for the primary single-family dwelling. Now you'll notice in that evidence, I continue to use the term primary single-family dwelling, and I'll indicate why I use that term further down. So in this next section, interpretations of a law or code, I pasted in here that particular section of our land use code, section 12C-515.2 A3, which reads as follows. The detached accessory dwelling unit shall only be allowed in a detached dwelling located on the same owner-occupied lot as the single-family dwelling. Only one detached accessory dwelling unit shall be allowed per single-family residence. Both the single-family dwelling and any detached accessory dwelling unit shall be owned by the same person or persons or entity, and they must share a single water meter and sewer lateral. A single-family dwelling and accessory dwelling unit shall receive one monthly bill from the city for municipal services that shall be sent to the owner of the lot on which the primary single-family residence and accessory dwelling unit are located. The proposed detached accessory dwelling unit shall not exceed 50% of the building footprint, including garage, of the single-family dwelling up to a maximum gross area of 1,000 square feet. If the accessory dwelling unit is built entirely over a garage for the primary structure, the entire structure shall not exceed a maximum gross area of 1,500 square feet. So that's just copy paste out of the code. Throughout the section of code that governs detached accessory dwelling units, which is section 12C-515, the terms single-family dwelling unit, single-family residence, primary structure, primary single-family dwelling, house, and residence are all used interchangeably. Similarly, this section of code uses the terms detached accessory dwelling unit, detached dwelling, and accessory dwelling unit interchangeably as well. This is, so the next section, I'm just kind of saying the way that I'm reading through this, okay, you might not agree, you might want to make some changes here, but as such, we interpret the following terms as used in the final sentence of the North Logan Municipal Code, section 12C-515.2 A3, which is that section that was bolded up here above. So using these, all of these terms that are used interchangeably, I wrote down a couple of bullet points to say maybe how we would interpret them. So accessory dwelling unit means the same as detached accessory dwelling unit. Primary structure means the same as primary single-family dwelling. And section 12C-515.2 is clearly intended to establish conditions for detached accessory dwelling units with an emphasis on detached based on the section title of conditions for detached accessory dwelling units. So everything below that title we would assume is for detached given the name of the title. So as such, we presume that any reference to a detached accessory dwelling unit built entirely over a garage for the primary single-family dwelling infers that such a garage is detached from the primary single-family dwelling. Therefore, we interpret the use of the term garage in this section of code to also mean the same as a detached garage. Okay. That's how at least staff read through this and is trying to piece it together. Okay. Lastly, we interpret the term entire structure by its plain meaning and as evidenced by the additional use of the defined term gross area in the same sentence. Gross area is defined in the North Logan Municipal Code as the sum of all areas on all floors of a building included within the outside faces of its exterior walls, including any garage space with stairwells counted only once, not including basement space. In this case, we interpret the entire structure to mean the gross area of the detached accessory building, including the detached garage on the lower level and the detached accessory dwelling unit on the upper level. So with these interpretations, the last sentence of the North Logan Municipal Code, section 12C-515.2A3 could be read as follows, with underlined terms replacing the original terms. If the detached accessory dwelling unit is built entirely over a detached garage for the primary single-family dwelling, the entire structure shall not exceed a maximum gross area of 1,500 square feet. So if we take all of those terms and say they are all used synonymously or interchangeably, I guess I should say, then perhaps we could read this sentence as it was there. So if we agree with that interpretation and understand the same, then we could reach these following findings of fact. One, the entire structure or gross area of the detached accessory building containing both the detached garage and detached accessory dwelling unit is a total of 6,400 square feet. The detached accessory dwelling unit is proposed to be located entirely over a detached garage for the primary single-family dwelling. So with those findings, we could conclude that the proposed detached accessory dwelling unit is built entirely above a detached garage for the primary single-family dwelling, and that the entire structure contains a gross area of 6,400 square feet, which exceeds the allowable area of 1,500 square feet. So that's if you interpret those things perhaps the way that I have, and the reason why I've read it and interpreted that way is based on the original motion of the discussion on February 2nd. So we all understand the original staff report read it differently initially, and the finding and the motion that the Planning Commission made differed with this last sentence of that section of code. So as I've put together these notes, I've tried to read it in the light that the original decision had read it in. If you believe these things to be an accurate understanding and interpretation of your original discussion and decision, then perhaps we could run with this and maybe spruce it up to where you could adopt it into the record for your formal findings, interpretations, conclusions. But that I want to just make sure everybody had a chance to listen through that note section that staff provided as a way to wrap your head around a way to look at this. Now, going back to Commissioner Payne's discussion of perhaps there's more evidence to support the fact that the garage is in fact a detached garage associated with a primary single-family dwelling. I think you're probably on a good thought process there, as there would potentially be evidence to support that idea. Based on the photos, based on the sketch, based on our understanding that there is not a stairwell leading from the garage to the upper living space, perhaps we could say they're not associated with them. And so it is built entirely over a garage that garage space is intended for the primary single-family dwelling. So if you wanted to add that idea in as a finding, we could probably do that.
Yeah, I mean, the other evidence shows that it is detached. My comments were the appeal authority mentioned it, the municipal code mentions it, our finding of facts mentioned it, but I don't know if we stated that or showed evidence that it is over a garage. And I think the photos show that. I think the layout provided in the application show that. I think we should mention it in some way. It doesn't have to be as formal as maybe what I had written there. But.
So I'd like to maybe work through this together so we're all on the same page. So I believe Commissioner Payne is pointing out evidence that we already have. The evidence being those photos, our understanding of the floor plan, and that is already, we do have a bullet point under evidence indicating there is photographic evidence of that point. We could probably add to this paragraph. So it says photographic evidence throughout the Cache County Assessor's Office indicates that the detached accessory building was built in the 2015-2016 timeframe, that the 1,482 square foot apartment occupies the eastern portion of the detached accessory building's upper level square footage. Perhaps I'll add a bullet point indicating that,
Comma. or
Yeah,
something.
you could put it right in there.
you know, just leave it in the same
Yeah,
line.
which,
The detached accessory building was built with a garage and upper, you know what I'm saying? You could put it right in there and leave it in that same bullet
Yeah,
point.
it's, yeah.
So that's okay.
Oh, yeah, no,
Yeah.
yeah.
Because all the pictures we saw, that's what it showed.
And yeah, the accessory dwelling unit is entirely above a garage.
Okay, this evidence would support that there is not direct connectivity to the lower garage space.
I don't even know if you have to go there. I mean, I think I think you can say that that evidence also shows that the accessory dwelling unit is above a garage. I don't think it needs to be more complicated than that. And it could be, does it need to be detached? No, just accessory dwelling unit, yeah.
I think reading through all of this, I've done several times, is exactly what we talked about in our first meeting.
Right.
And Teresa, you have something?
That's what I was gonna say, and I think that we didn't include probably in our motion that we should have, if you look at on page 1, under the interpretation of when it says the entire structure. I don't, we probably should have included the entire structure. Is over 1,500. Do you know what, understand what I'm saying? I think
Yes,
if we would have done that, because we talked about it.
yes,
We had that discussion, this is bigger than 1,500.
They said the structure.
And it
The
says
entire
The
structure.
entire structure, that's what it says.
I think what we've learned is we have to be very specific. But
So
I think,
if-
go ahead, Scott.
No, I just want to make sure I'm on the same page. So under the findings of fact, number 1 here, the entire structure dash gross area of the detached accessory building containing both the detached garage and detached accessory dwelling unit is a total of 6,400 square feet. Does that satisfy?
Yeah,
your-
and I don't,
Yes.
and if you wanted to add to that, you could say with 3,200 for the garage and 3,200 for the second floor.
But
But you don't need.
I don't think we need to add that.
Yeah.
It's the total.
The entire structure gross area measured outside of wall to outside of wall is, that's a defined term in our code, gross area.
Yes.
Okay. Now, we did also get an email from Kenny.
Yeah.
And I'd like to just open that
Yeah.
up real quick and read that just into the record here.
Only, and I mean, no disrespect to you, but I feel like I've gone to a hating party and the verdict's been entered. We haven't even had an opportunity to address.
Yeah,
We'll let you address it in a minute. We're going to hear what our other commissioner has to say first, okay?
okay, so this was an email from Kenny just yesterday. Scott and fellow commissioners, I'm writing you from Washington, DC. This has been a very busy time for me at work, and it is not looking likely that I'll be back in time for our Thursday planning commission meeting. Please accept my apologies again for probably missing a second consecutive meeting. In the meantime, I did review the material you provided, Scott, on the denial of the Hopkins detached ADU CUP. I agree with Mr. Hansen's points in his decision of appeals hearing officer letter, and I can definitely see how he was confused at how the commission reached the conclusion to deny the CUP. However, based on my review of the material provided and the North Logan Municipal Code, I still feel like the commission's decision to deny the CUP was the correct one. I agree with Mr. Hansen that there exists an ambiguity in section 12C 515.2A3 of the North Logan Municipal Code with respect to maximum allowable square footage, and I agree with him that it does not make sense for this section to be talking about a detached ADU built entirely over a garage for the primary structure. Since it wouldn't be detached in that case, we should fix that language. However, I'd like to point out that the denial of the CUP was not based on that poorly written ambiguous last sentence of this section. It was actually based on the preceding sentence, which states the proposed detached accessory dwelling unit shall not exceed 50% of the building footprint, including garage, of the single family dwelling up to a maximum gross area of 1,000 square feet. The Hopkins detached ADU is both greater than 50% of the building footprint of the single family dwelling and also greater than 1,000 square feet. So it does not meet either of the constraints outlined in this sentence. Unfortunately, Jeff's motion to deny the CUP contained a slight error in language that compounded the confusion on this reasoning. The minutes from the commission meeting state Jeff Coleman made a motion that the planning commission does not grant the conditional use permit based on section 12C-515.23 of the North Logan Municipal Code, that the structure is larger than the maximum gross area of 1,500 square feet. The unfortunate error is that Jeff said 1,500 square feet instead of 1,000 square feet, which made it unclear that he was talking about the second to last sentence in section 12C-515.23 and not the last sentence about it being above the garage. If I were to make this motion again today, I would say that the planning commission does not grant the conditional use permit based on section 12C-515.23 of the North Logan Municipal Code, that the structure is larger than the maximum gross area of 1,000 square feet, and it also exceeds 50% of the building footprint, including garage, of the single family dwelling. In my discussions with Jeff on this topic, I am confident that this is what he meant as well, but in the frenzy of that meeting, he got his numbers mixed up. I wanted to make sure I communicated these thoughts to you all before Thursday's meeting. Hopefully I get home in time to join you in the meeting, but if not, at least you have my thoughts here. So that was an email from Kenny on the topic.
Okay,
Any other discussion with the commission, or would you like to open it up to the applicant to address the information here?
did you have a question or thought, Heron?
Oh, I just wanted to say on that one where it says right where that, I don't know what you call that. If the detached accessory dwelling unit is built entirely over detached garage or the primary single family dwelling, the entire structure shall not exceed a maximum area of 1,500 square feet. I'd like that inserted someplace.
It is.
It is.
In
So-
It's in there.
and this whole thing we can adopt. It's
in
whatever
Okay.
language.
All right.
whatever-
I like that.
Hey, any other comments right now?
I would like to hear from
Yes.
him, so I'm
Wait,
okay to
Before we,
talk later.
before we make a motion, we'll hear. All right.
Okay.
Comments? Can you come up to the microphone, please?
Since it's in my name, may I have my wife speak first, Janae Hopkins, and then Joe Chambers, who represents us, speak after that? Is that allowed? Okay, thank you.
Thank you. I appreciate this opportunity. It sounds like kind of what we're stuck on here, and I understand it's your responsibility to interpret these things that have been written. I'm not sure whether to talk about 1,000 square feet or 1,500 square feet, but it seems pretty clear that you reached your conclusion based on 1,500 square feet, that this is indeed above a garage, which it indeed is. We invited the commission to come and view the property. The fire marshal came and viewed it after this commission.
They haven't inspected it and it's got a rec room down underneath it. It's a recreational room. There's not been a car parked in there. Have you ever parked a car in there?
I haven't personally, no.
No, and neither has anybody else.
But based on the 1,500 square feet, I think some, sorry, there's two thoughts that I have, and I'm just trying to figure out how to explain it. No, it's okay. When the commission is looking at an interior, so we're not asking for a building permit, right? This structure's been existing. We can agree on that. It's been existed for 8 years. We purchased this property. It was represented as income potential property where you could, rent out a portion of that property, right? That's the understanding that we had. So you can understand, we were frustrated when we were told, no, now this can't be that because we paid for that. We're taxed that way. So what we're asking is a use permit and that's before us now, not building, right? If we're talking about a use permit and this were interior to the home, you certainly wouldn't look at the entire structure of a home. You would look at the space that is going to be used as a rental unit, right? So why would that be different in this case? Now, all of a sudden, we're going to take it, we're going to say the entire structure can't be more than 1,500 square feet. If you read it that way, that it can't be more than 1,500 square feet if it's over a garage. Most garages, if you look at the square footage of a garage, then what would be left for a unit? It sounds to me, if you read through there, it's saying if it's in a home, a maximum of 1,000. We'll go up to 1,500 if it's over a garage. To me, that's saying we allow it to be bigger if it's over a garage. And in this case, it's clearly under the 1,500 square foot mark. It is completely inaccessible from the rest of structures, including that dance studio that was built, totally separate entrance to that. So in my mind, I just don't see how we can take interpretation for interior units and apply that separately because this is interior to that second unit. Those are just my thoughts right off the bat. I know it was a frenzied meeting. Emotions were high. Things were really difficult. I just would hope that this commission would take a step back and look at the intent of that. I actually spoke with a gentleman who served on the planning commission when this was enacted. And he's like, I'm sure when we wrote that in, it said the entire living quarters couldn't be more than 1,500 square feet. He's like, I'm not sure where that got taken out later on. This could be something that happened at the city council level. That's maybe something you could research later. We're welcome. We would welcome you to come in and inspect the apartment and look at it. We were asked to submit a hand-drawn drawing last time, which we did since then. Because the city couldn't locate the plans, we contacted the previous owners. They searched through records and found the plans, which we submitted to the appeal authority that shows actually the square footage is slightly less than what it says here. It's under 1,500 square feet. That's really just all I have to say. And I appreciate you looking at that. Thank you.
Thank you. Thank you.
Good evening. My name is Joe Chambers. I'm not here to tell you what to do. I'm here to just make sure that everybody has the same understanding of the facts. You keep referring to this structure that was at one time originally a garage, but when my clients purchased it, it was a recreational room. If you go into the property, the entire former garage floor has been painted and is used as a recreational area, has toys in it. It has a basketball area. And we would invite you to go up there and if necessary, the planning commission, as a planning commission, I sit on the Providence Planning Commission. I used to be the appeals authority. We had a board of adjustments, not just a single appeal authority, but we had a community member board of adjustment. I live in Providence. And so I understand that you guys donate your time, but the situation here is the ordinance got passed and we addressed this at the appeal authority. This ordinance that deals with detached accessory dwelling is a third generation ordinance that comes from the internal dwelling unit and the definitions in here somehow got entirely mixed up. As Mrs. Hopkins said, it makes no sense that you can have a proposed detached accessory dwelling unit that can't exceed 50% of the square footage and have a gross area of 1,000 feet if it's internal. And yet the entire structure, as opposed to the living quarters, can't be over 1,500 square feet. If you apply those terms, I mean, literally apply those terms, it comes to nonsense. So first off, you have indicated that for the bulk of the meeting that I've been listening, you've been calling this structure that the apartment is built over a garage. Go look at it, inspect it. You don't have a process where you can take testimony, but I'll make a proffer to you because I checked with my clients, they have never parked a car in there while they've owned it. And it's finished off as a recreational play area. And so it's not a garage. So if you literally read your ordinance, if the accessory dwelling unit is built entirely over a garage, it's not a garage. And you just totally ignore that area, that portion of the code. It was a garage when it was originally built, but that doesn't mean that it is a garage now. And if you take a look at the definition of your ordinance in section 12A 200 of what a garage is, it does not meet that definition. You know, based on what the Utah legislature has done over the past 2 years, that they want cities to make accessible housing available to people. Our road funds are penalized if we don't do it. They've added penalties on it. And I don't know what you as a city have done to meet the guidelines of the state, but this accessory dwelling unit is expressly designed to meet the fact that you are making dwellings available to the people. And I think from a public policy point of view, that's one of the reasons why cities enact accessory dwelling units, is to make dwelling units financially feasible for other people other than the ultra rich. Utah Code 10-9A-507 indicates that if it meets the terms of the ordinance, that a conditional use permit shall be granted if there are any conditions that can be attached to that would mitigate whatever harm you see to it. It's not a discretionary deal. It is a mandatory. It shall be granted. And if you take a look and if your staff would wanted to go ahead and pull the Utah Code up, you can see that I'm not exaggerating that. That's because conditional use permits are a property right. And the legislature has said, if you meet the conditions of the ordinance, then it is obligatory for you to find conditions that would mitigate any problems that this use of it, the conditional use of it as an accessory dwelling unit, can mitigate to the community. The staff report, which I think is important, and I realize that Scott now has assisted you in finding ways to go back to the old resolution that was appealed and remanded back to you, to how to strengthen that and make it semi-appeal proof. But again, you don't have the essential fact, because you're calling it a garage, and my clients are here, and if they need to be placed under oath, I'm a notary, I can place them under oath. They will testify that it's not been used as a garage by them ever since they owned it, and when they bought it, it was not used as a garage. So I think you have a real problem without going up and inspecting it and verifying that it is a garage. We're going to be in the same position coming back here, that there is evidence presented to you in my proffer that it is not a garage, and we're allowing you to go up and inspect it, or send a staff member up there to inspect it, and they will find out that it is not being used as a garage, has not been used as a garage, and is not suited for use as a garage. That gets down to the square footage of the property. Our understanding is that the primary structure is has a square footage of 3,836 feet. And the garage has the garage area that you keep referring to as a garage, which I'm telling you is not, is 3,200 square feet, for a total of approximately 7,036 square feet. If you go to your ordinance and if you want to put it up, Scott, you can possibly assist them so they can see what I'm talking about. And it's the section 3 portion of it. Yeah, and wasn't that it?
Is that legible for everybody? Can you see that?
Yeah.
That's as big as it'll let me go, I think. There we go. This is 3 right here, I believe, what you're looking for.
Yeah. The proposed dwelling unit will not exceed 50% of the building footprint, including the garage. That language to me, the building footprint, including the garage, means that you take the 3,836 square feet of the building, include what you keep calling a garage, but which is not, of 3,200, that's 7,000, over 7,000 square feet. Okay. Of the single family dwelling, up to a maximum gross area of 1,000 feet. If the accessory dwelling unit is built entirely over a garage or the primary structure, the entire structure shall not exceed a maximum gross area of 1,500 square feet. If you read that literally the way it's written, it means that the entire structure, the 7,000 square feet, 7,036 square feet, cannot exceed 1,500 square feet. It makes no sense. And that's using your own definition. So what does it mean? It obviously means what Mrs. Hopkins was saying. That as long as the accessory dwelling unit is under 1,500 square feet, it's allowed as a conditional use. Ignore this last sentence entirely if you want. Because this is not built over the garage. It was built over a structure that was once a garage. But if you go on the first sentence and ignore the second, then they're entitled to a conditional use permit of an accessory dwelling of no more than 1,000 square feet. And they will cut down the structure to what they need to 1,000 square feet. And I think it's obligatory under this type of a situation that they're entitled to the conditional use permit. The problem with the February meeting and sitting on a planning commission in Providence where we have almost our entire community against higher density housing over there, to the point that we had a referendum a couple of years ago. I know what public hearings do, and they bring out a lot of clamor. This body is an administrative body, and you're to make decisions not based on public clamor, but based on the ordinance, and particularly where a conditional use permit is involved. State law overrides the city code. And if the state law says that there are any conditions that can be met that would mitigate whatever concerns the planning commission has, then you put the conditions on there and you must grant the conditional use permit. I'm not trying to beat you up and as a lawyer, I respect the job you do. I am trying to get to the right result here. And the fact is that someone messed this ordinance up grossly, poorly. And it just does not make sense. When the public meeting happened, and I don't understand why and I said this at the appeal hearing, I don't know why North Logan City Council wants you guys to have a public hearing for every conditional use permit on an accessory dwelling unit.
Let's just address this, okay, Mr. Chambers?
Sure.
If are you finished, or do you still have more to say on this issue?
No,
Not the rest of our municipal code.
no, it's not. But it can be made sense of with common sense. And evidently you're entitled to interpret it. And any other interpretation just doesn't get there.
Okay,
But you wanted to address something?
no, are you finished with this?
No, I'm just saying that I think the public clamor that was at the last hearing prejudiced the clients, and I think public clamor is totally inappropriate at an administrative body hearing like this to the public as a planning commission. The staff report recommendation that recommended the approval of it, I felt applied a reasonable interpretation of the ordinance. The commissioner that made the motion did not agree with him, and that's your job to do. But I don't think you have any evidence that this unit is built over a garage.
Thank you. Anybody else? Go ahead.
Wanted to speak to.
Hi there, my name is Nate Whitaker. I'm an interested neighbor to the Hopkins property. And I just wanted to point out a couple other things that it seems like there can be a couple different interpretations of that last sentence that we talked about. We agree that it's ambiguous. And in fact, the attorney at the appeal authority pointed out that
Nate, real quick, I just want to make sure, we haven't opened a public hearing. I want to make sure the applicant's okay having Nate speak on their behalf. Okay.
yeah, the attorney pointed out that the language is so ambiguous that it opens up North Logan City to all kinds of litigation. Those were his words. And if you look at the prior versions of this code, it seems like it was just kind of hodgepodge and tried to make it work to apply to our current circumstances. This isn't written as if it was started from, the very beginning. And so that's why I think it's very confusing. It was all an accessory dwelling unit in the language of the prior versions of the code was just all thrown together. And now over different versions of time, they've tried to separate attached versus detached. And so that's why it's very confusing. I think the point of interpretation, or it can go one way or the other, is here where it says, if the accessory dwelling unit is built entirely over, that can be interpreted two different ways. If it is built over the entire structure, then the entire structure can't be more than 1,500 square feet. The intent was, if you're going to build a building, a garage, and you're going to have an accessory dwelling unit over it, and it's going to be over the entire structure, then that entire structure can't be 1,500 square feet. But this accessory dwelling unit is just in a portion, less than half of what we're calling the garage. And so therefore, it meets the code. That is how I interpret it. That is how I see the original writers interpreted it. The other point is if we stick to the conclusion that this accessory dwelling unit be denied, it creates a worse situation for my neighborhood. Because the Hopkins have a business permit, they have the right to run a short-term rental out of their property. If they can live in the accessory dwelling unit, then they are on site. They get to monitor everything that's going on. They can make sure that cars are parked in the parking lot and not on the street. They can make sure that the noise levels are down. But if they can't live on site in this accessory dwelling unit, then in the same reservation, they can have parties of 50 people opposed to 28. Because in the same reservation, they can have guests in the primary dwelling, the house, and above the garage. And it would be totally unsupervised. So now we neighbors are going to have a whole lot more issues because it's unsupervised. The city is going to receive a lot more complaints to regulate. And the Hopkins are going to have more complaints. And so I recommend that you look at the other interpretation, which I think was the original intent of this writing, which is to allow an accessory dwelling unit above the garage below 1,500 square feet. Another way you could say that is, if you're interpreting it as if the accessory dwelling unit is built so the whole of it is over the garage, then why not just extend 2 feet beyond the garage? Then it's not entirely over the garage. And that's a simple fix, right? That's not the intent of the original written code. And so I'd ask that you consider that as well in your decision. Thank you for your time.
Thanks, Mr. Whitaker. Mr. Hopkins. Certainly. Thank you.
Thank you.
Thank you for your thoughts. Did you have any comments? Okay.
We don't want to beat a dead horse, but I know last time it was a concern, and maybe you're not talking about it now, but before it was a concern whether we lived in the larger structure or the smaller structure, but it said, and I didn't have it in front of me at the time, but it says right here in the code, 12C 515.3, it says, saying that the owner will occupy the primary single-family residence or detached accessory dwelling unit on the premises. So before you find a conclusion, I just want to make sure you understand that that is in your code, that we are within our rights to live in either one. So I appreciate your time. Thank you. I know this has been long.
That it? That's the comments? Okay. Teresa.
I think it's really hard for any of us to know what the intent was. I don't think any of us know what the intent was. And that happens sometimes. It happens with code, it happens with policy. We don't always know the intent. And so it's up to who's ever reading it to interpret it the way they understand it. And that's not going to be the same for every person. But for me personally, when it talks about what Kenny was talking about, where it caused about the proposed attached accessory dwelling unit shall not exceed 50% of the building footprint, including the garage of the single family dwelling, which we're told is 3,832 feet. If I wrote that down wrong, if I didn't, I'm sorry. Up to a maximum gross area of 1,000 feet. But honestly, in my opinion, the detached accessory dwelling is the upper floor. It just is. I mean, if I have, if I have storage areas in my house where I store things or something, that's still considered part of my house. I mean, to me, that's just, I interpret the second floor of that building to be the accessory dwelling unit. And that's just how I interpret it. I'm not, you guys can interpret it however you want. That's how I interpret it. And if we want to go to the second one, when it talks about building over entirety of a garage, that's originally was built as a garage. It originally was, and to say, well, it's not a garage now, okay, we can determine that, but in my mind, it is above a garage and it does exceed 1,500 square feet. Then that's my interpretation of it, which isn't going to be the same as everybody else.
You have something, Scott?
Scott, did you have something?
I don't want to interrupt your discussion. I do have a couple of clarifications perhaps, but I can pitch in whenever. If you guys want to continue your interpretation, your understanding, I don't want to jump in if you guys are in the middle of that.
I've got a couple of things.
Go ahead.
If you want me to. I think a lot of it's based on the interpretation of the code. The code to me is pretty straightforward. And I have a question as I wrote down, access to, we'll say, the garage, is that by garage doors or a different door? Okay. Then okay. Correct. Okay, correct. As Mr. Chambers mentioned, it is not a garage now, but is used as a painted floors, a basketball area, play area. In my thinking, then that becomes part of an inside living area for the family. Okay. That was just a thing that popped in my mind. If I have a play area in my home, that's still part of my footprint of my home. Another one, it's an accessory dwelling, but it still, in my reading of the code, still exceeds the city code. So that's where I'm coming from.
A point of clarification, the planning commission is intending, when an application is brought before the planning commission, the application as submitted by the applicants, in addition to any information that the city may have available to it, is reviewed by the commission to determine compliance. We haven't received any evidence that the lower level is anything but a garage. I'm not saying that maybe it has been renovated or changed since then, but the evidence that we have with the county assessor's office show roll-up garage doors, what we would typically see on a garage. And so the evidence that was submitted and reviewed and used in the determination by the planning commission is limited to that. Now, we've heard during this meeting, perhaps more anecdotal information that maybe it's not the same thing as a typical garage, but that wasn't what was originally submitted to be reviewed of the application. Another point of clarification to Mr. Chambers' comments, he is correct. We cannot deny a conditional use permit if there are conditions that can be applied to reasonably mitigate anticipated impacts. But state code goes on to say that we can deny if the application simply doesn't meet the standard. And I believe that the intent of the planning commission was to find that this structure doesn't meet the standard. And then we need to clarify what that standard is. 1,000, 1,500, entirely above a garage. Those are the things that need clarification from the commission based on your understanding to support that finding, and then the motion to deny on that finding. So you can deny if that standard is not met. And I want to just kind of be clear, we're not here to talk about public clamor. We're not here to talk about whether or not the unit is supervised or unsupervised by the owners. And we're not looking at whether or not they're allowed to use that as a primary residence versus the larger unit. We're simply here to say, can this be permitted as an accessory dwelling unit regardless of who is occupying the structure? So let's not get that confused here.
And we're not talking about short-term rentals either.
Correct. Nothing to do with short-term rentals. So I want to kind of get back to, we as a commission are tasked with determining what evidence do we have? What are the facts that we pull from that evidence? What are our conclusions? Does that evidence meet? Does the evidence show that we meet the standards in the code? And then what are our interpretations if needed to then either approve or deny? So going back to the note section here, we have a list of points of evidence. Now we can add to this if we believe there's more evidence that was part of this decision or not, we can add to this. The interpretations that I've provided, I hope that we add a little bit of clarity in the sense that a lot of these terms are used interchangeably. And if we agree, if you guys find that those terms are used interchangeably, then we can go ahead and say, okay, we do agree that all of these terms for residence, single family, detached, those things are all the same. And maybe we should take a temperature reading from the commission to work our way through this. Maybe that would be the best way to get this document where it needs to be to potentially be adopted by the commission as their formal findings of fact, conclusions of law, and interpretations. So is that okay if we approach this methodically?
Yes.
And try to get it from top to bottom?
Yes.
And
And I
add as
also-
needed, subtract as needed?
And what I wanted to say is no matter if we like our municipal code or not, that's what we have to work with right now.
That's the black and white.
That's the black and white. That's the rules, the things that we get to make our decision on, no matter whether we like it or whether you like it. That's what we have to go with. So,
Correct.
Scott,
Okay, can we agree on this first bullet point here that the apartment, the floor sketch plan as submitted by the applicant depicts a dwelling area of 38 feet wide and 39 feet deep for a total apartment area of 1482 square feet. Do you want to use total apartment area? Do we want to say accessory dwelling unit?
I'll see what the apartment has to do. The size of the apartment, to me, because it's. So I don't know.
You're saying you think the whole floor should be the apartment versus,
Well, that's what I consider the accessory dwelling unit.
I think that was one of the issues last time is there was a storage unit on one end that nobody was going to use and then the apartment.
Okay, real quick, we can make that a finding. We just want to say, what is the evidence before us? We can say the
Yes.
evidence would suggest that the entire apartment is 3,200 square feet below. We can make that a finding. The evidence,
We just know that's the size of that.
correct. We can say that we have some evidence by that sketch that was submitted. We also have evidence from the county records, the assessor's office, that there's 2 levels, 32 on each. If we want to make a finding that the dwelling space could be as big as 3,200 square feet, we could make that a finding as well. I want to make sure we're just identifying the evidence.
Okay.
Okay.
I've got a question on that one. So we have in evidence the pictures,
Correct.
we have in evidence the application, we have in evidence the hand-drawn floor plan.
Correct.
I heard mention of finding the old floor plan. Do we have that in evidence? Has that been submitted to the city?
That was not submitted during the original application. It was identified later and submitted to the appeals hearing officer. Which is another piece of documentation that wasn't presented to the planning commission during the original application.
So that's not in evidence for us.
Has not been entered into the record for the planning commission. It did come up during the appeal submittal. So the applicant had to submit documentation to the appeal authority. That included that more professionally drawn building floor plan. But that has not been brought before the planning commission. It could be if you wanted to request it, if you think that would make a difference in the outcome of this, or if you needed more evidence to, maybe you would say that we don't believe the county records, and maybe that, the original sketch would be better evidence. This is what the evidence we have so far. There may be more evidence that could be submitted if we believe it's needed to support your findings and your conclusions.
God, we also have mentioned the I would like included in there is the county square footages that also added as evidence.
Okay, that is a bullet point here. So the county assessor's office records indicate that the overall square footage of the detached accessory building is 6,400 square feet, 3,200 square feet on each of the 2 levels.
Right.
So that is a piece of evidence
That's
we've
evidence.
listed.
Good.
Yep. Sure. Would the planning commission like to have that formally submitted to the commission? From a procedural standpoint, I'm not quite sure when or how that should formally be brought to the planning commission. Perhaps now is fine.
I'm gonna ask one question before answering that question. What is in our code, do we have a definition for garage?
We do. I'm happy to pull that up if you'd like to look
If
at
you
it.
would, please.
Yep.
While he's pulling that up, if you guys would like to cross this whole meeting, challenge us to meet certain circumstances and come back to you, we'd be willing to do that. No one ever has asked us, no one has ever engaged us, but we're very, very open and willing to meet whatever standard we have. But I don't feel that that's going to be a possibility from your standards, but we're open to that ourselves. If you would like to discuss that, we've always been very open with anyone and everyone that's come and talked to us. And we would be willing to consider any alterations. Any alterations to the building itself, we're opposed to those. We'd be willing to do that to meet whatever standards you have. You needed stairs here, or walk something more off there, whatever you would like, we're willing to consider all of those in order to be.
And additionally, the city actually came and inspected this unit afterwards, like it's called me, but we didn't know why they came and, yeah, for your conditional use permit, this is after you're approved, then you get inspected, we're like, well, we were denied, they're like, oh, well, okay, we'll inspect, and they've inspected, so maybe you could get that.
Couple of clarifications. So the inspection was for your short-term rental, not for the detached accessory dwelling. Did you? Okay. The other thing, if the applicant wanted to request to close this application and say, we're just going to close this and we'll resubmit with a plan that we think may be able to meet the standards. If they don't believe that it meets the standards currently, they as the applicant can withdraw their application, work. Perhaps. Let's do this. Right now, what we have to do before the commission, we've made a decision during a past meeting. We've had evidence submitted to us to date. And we've had a request from a remanded appeal to make some findings of fact, which of law, add that to the record so we can take another step. Now, if the applicant says, hey, I don't think this thing has legs and I don't want to go through this process, I don't think it's going to get anywhere, you can select to close this application, withdraw it, and then resubmit with a new proposal you believe could meet the standards as they're currently written, if you think there's a better opportunity for you to get an approval. If your thoughts are this existing building could potentially be modified in a way to meet the standard, I don't know that it could. I guess it would be helpful to have the planning commission finalize this discussion and make those findings. And maybe then you would be able to go back and think about maybe could this building be adjusted, yes or no, to meet the interpretation of the code as discussed by the planning commission. But I think at this juncture, just for the process we have before us, it might be good to finalize a discussion, come to specific points of evidence, findings, interpretations to put a bow on it, so to speak.
Do that, so even if the ball are moving forward, there are very few options. I'm trying to.
Not necessarily. When and if we put, more evidence, facts and findings, written facts and findings into the record, you could then go back to the appeal authority and see if the planning commission was correct in their interpretation of the code. If not, it may be overturned and your conditional use permit would be granted. You may also say the code is too ambiguous. You need to err in favor of the applicant. So I think at this point, the best decision right now, from staff's opinion, is to have this discussion. Let's make sure, based on the language that's in the code right now, we make some interpretations, we make some findings based on the evidence that was presented before us. We enter that into the record, then we put that bow on it and take it back to the appeal authority. My personal thoughts on that.
That they can then favor.
They could. Let's make sure. I think it may be best. Let's have everybody go to the front row. If you'd like to say something, let's make sure it's into the microphone.
Yes, I'll
Let's
make Marie really
keep this
happy.
formal as possible.
Oh, sorry.
Okay,
I
thank you.
think as a commission, I think we would like to go through and finish Scott's idea. Because right now I don't think you would like what we have to say. And we're trying, and we're not bad people. We're not mean people. We're trying to, we would like to work with you, but we have certain parameters, good word,
Let's-
that we have to work with. So let's finish. Yeah, well, and we weren't around when the previous owners did whatever they did. So let's go through, let's finish Scott's
the garage.
idea. Let us go through all the evidence and then we'll go from there. Okay?
Thank you for bringing this up. So I've read it and I understand what we say a garage is. Is there anything in evidence that identifies it on a plan, on a drawing as a garage, labeled garage? And if not, that's the reason I would ask for the stamped engineered plan. Does it label it a garage? So I'm looking for anything in evidence that calls it a garage.
I might want to pull back up the exhibits that were submitted in the original application. I don't want to rely on my recollection, if that's okay. One other thing, just I want to keep these proceedings as formal as possible. Let's keep anybody in the audience. Let's keep your comments unless you have been asked by the chairperson to speak into the lectern, okay?
We're not going to change the code tonight. And that's it. Let's just go ahead. Just so you know.
Okay, let me hop. This is the original staff report from the February 2nd meeting, which includes the the drawing here. So we did not have a lower level submitted as part of that original sketch. We did have the upper level, the unincluded space as labeled as dance studio below. You see those doorways that were discussed being separate from each other. Also, I think of note in this, going back to Commissioner Payne's discussion, there is not a set of stairs leading from the garage directly up into this living space or any space above that lower level. These are those photos from the county assessor's office. So we can see kind of around the perimeter, there are no stairs leading up to the building. This is that rear portion of the building as it was being framed. You see those garage doors, the roll-up doors. And that was part of the original staff report. Now, the county records, which did not make it into the staff report as a formal exhibit, they do show a sketch plan, a rough drawing that they use for assessment purposes for estimations on square footage. That may or may not indicate a label showing garage, may or may not. But I do know that staff did rely on that county assessor's information to arrive at some of those square footages as well. So I think it could be reasonable to pull that up if you'd like to see specifically if there's a note. Although that's up to you if you think that's pertinent to your findings, evidence, and a finding that points specifically to that piece of evidence. I don't think so.
We have, Gavin, you have something to say?
I'm just kind of trying to process through it all. So I've got a note and we'll see where this goes and I may ask for it later, but.
Okay, so we're ready to move on?
If you'd like to continue going through this set of notes in a methodical method, then perhaps that would be good. That would what the commission would like to do.
Yes,
Okay.
yes.
Any other pieces of evidence you would like to make sure are included as a bullet point? Okay, we can come back if we need to. Looking at the interpretations. So this is just copy paste that section 3 that we seem to be hung up on a little bit. I want to let's get a temperature reading on this. So throughout the section of code that governs detached accessory dwelling units 12C-515, the terms single family dwelling unit, single family residence, primary structure, primary single family dwelling, house, and residence are all used interchangeably. Is that something that the commission agrees with, that statement? Can those terms, as used, all those terms are used in that section of code. Can we agree that they are used interchangeably?
Yes. I
Yeah,
so.
okay.
Yes.
If we're on board, let's go to the next piece. It says, similarly, this section of code uses the terms detached accessory dwelling unit, detached dwelling, and accessory dwelling unit interchangeably as well. Those three terms are all used to describe this accessory dwelling. Do we agree that those terms are interchangeable? Okay.
Yes.
So if that's the case, I do believe that we could work through that to conclude this sentence below. If the detached accessory dwelling unit is built entirely over a detached garage for the primary single-family dwelling, the entire structure shall not exceed a maximum gross area of 1,500 square feet. So if we really can say that these things are interchangeable, these two underlined phrases could maybe add clarity to that sentence. The other thing, this detached garage, when we look at the section as a whole, the section 12C 5152, it's the title of it is specifically stating that it's for detached accessory dwellings. So the mentioning of a garage for a primary structure, I still, in my interpretation is that that garage is detached from that primary structure, and that if we are putting an accessory dwelling unit above that garage, then we could just say, if we're using, let's go back here, built entirely over a detached garage, we could say that detached garage is for that primary single family dwelling. If we agree with that, then this sentence could theoretically be interpreted saying, if the detached accessory dwelling unit is built entirely over a detached garage for the primary single family dwelling, the entire structure shall not exceed a maximum gross area of 1,500 square feet. So if we think those terms could fit in that context to clarify what that sentence could mean, then we need to understand this entire structure. And when you look at this bullet point above, lastly, we interpret the term entire structure by its plain meaning and as evidenced by the additional use of the defined term gross area in the same sentence. So when you look at this sentence, we say built entirely over a garage for the primary structure, the entire structure shall not exceed a maximum gross area, and it's capitalized. It is a defined term in our code. And that definition of gross area is defined in our code as the sum of all areas on all floors of a building, including within the outside faces of its exterior walls, including any garage space with stairwells counted only once, not including basement space. So basically the four walls, anything in between, that's gross area. So if we're looking at this building, the entire gross area, we have evidence from the county saying it's 6,400 square feet. Okay. If we agree with that being entire structures being the same thing as gross area, then we could find that the entire structure dash gross area of the detached accessory building containing both a detached garage and detached accessory dwelling unit is a total of 6,400 square feet. And so that right there is a finding that we could say, okay, it's 6,400 square feet total. That is the gross area. The other finding is the detached accessory dwelling unit is proposed to be located entirely over a detached garage for the primary single family dwelling. Is it built entirely over? You know, there's been some discussion tonight of what entirely over means. And that's that's an interpretation the commission will need to decide. You know, based on the evidence provided to us, that detached accessory dwelling unit, the 1,500 square feet that they have proposed, is contained entirely over that garage. That I don't know that that's ambiguous in my mind. Maybe there's some interpretation from the commission of how they read that. But if you can find these two findings, then we could conclude that the planning commission concludes that the proposed detached accessory dwelling unit is built entirely over a detached garage for the primary single family dwelling. and that the entire structure contains a gross area of 6,400 square feet, which exceeds the allowable area of 1,500 square feet. Based on the above evidence, interpretations, findings of fact, and conclusions, the North Logan City Planning Commission hereby denies the requested conditional use permit for a detached accessory dwelling unit due to the entire structure of 6,400 square feet exceeding the allowable gross area of 1,500 square feet. Now that's a stab that staff took, and let me know if you have other interpretations that differ from mine. But if you want to add to this, let's add to it. If we want to detract from it, let's detract from it. But if we are in agreement with that, we could adopt these pieces of evidence, conclusions of law, findings, and then the conclusion that it should be denied. We could adopt this, put it into a notice of decision as part of the formally adopted record, and then move that forward. Now, the appeals hearing officer, let's say that we do that. Hypothetically, we do that. We add it into the record tonight. And the applicant takes it back to the appeals hearing officer. The appeal hearing officer is then charged with reviewing our findings and our interpretations to see if we got it right, if he agrees with how we interpreted the law. If he thinks we erred in our interpretation, he could overturn our decision and go ahead and grant that conditional use permit. He could also find that the code is too ambiguous and that we should have erred in favor of the applicant and granted the conditional use permit from the onset. That is a path that could be taken. But if he agrees that, yeah, maybe our code isn't perfect, but our interpretation of the code is sufficient to deny or sufficient to find that it does not meet the standard, then he could uphold what the planning commission's decision was to deny the permit. So that's where it could go, but we need to get to the bottom of what is the evidence, what is our interpretation of the code, what are our formal findings based on our evidence and our interpretation of the code, and what is our conclusion.
Scott, a quick question. Would it be helpful to add photographs of the ex dwelling into this?
I think we have, by having this bullet point at the top of evidence indicating that there is photographic evidence of the structure. Yeah. Is there anything in here that anybody felt like they didn't quite agree with? Or maybe read differently?
Possibly, but I'm having a hard time putting it in words. I just feel reading things a little bit off from
Sure.
everyone and interpreting. I kind of am seeing everyone's interpretations, and that's getting a little foggy for me.
There's a lot.
If
to
I'm
wrap
being
your head
really
around.
clear.
Now, and also to be clear, you don't have to take any action tonight. We can table this if you need more time to wrap your head around it. That's an acceptable option as well.
Dan loves it when we do that. You can tell.
No, I don't like it when you do that.
To me, this is clear with what we have to work with.
Yeah.
The way I read it, I would have to agree with all of these findings. The way I read it, the way we talk about the entire building, to me, it makes sense. I know the picture
Mhm.
that was sent, the apartment was this and the storage area was this, and I'm sure that you would like just the apartment to be included in this. But in my mind, we have to include the whole area, the whole structure. And so when we do that, how it's written here is exactly what I would have to agree with. So that's my interpretation. Anybody else?
I would say the same thing. My interpretation of what the square footage is and how you calculate square footage in a building. And we've done the best we can. And I would support what our findings are.
And that's what I said a little while ago.
I think as I look through each of the points, I think the apartment, since it has separate entrances, separate from dance studio and all those things, I think that's true. that's a true statement of evidence. But when you look at the code, it's not talking about that, it's talking about the entire structure.
Yeah.
And
That's true.
I think the built entirely, if you look at the grammar of it, the built entirely is applying to the accessory dwelling unit, not to the garage, or they would have worded it if the accessory dwelling unit is built over the entire garage. So I think that is related to the accessory dwelling unit. And then as we look at primary structure, I think the interpretation section you have here and the way you've laid this out based upon the previous conversation, the planning commission, I can follow that. I think all those things are logically laid out. And so the only remaining question I have is garage. Is it a garage? And I think if the initial application, any of the anything that's in evidence shows it's a garage, then I think that bolsters the case that it's a garage. I look at it and I see garage doors.
Right.
And I see it separate from a home. And if you ask me, I would say it's a garage. But again, but we have no evidence of its use, its internal use. But I don't think we have, unless somebody has, we have it in evidence, nothing. It would be nice to say the plan labels it garage.
But there's no evidence to the contrary
Correct.
either,
Right, and it appears a garage.
at least as far as what was submitted with the original application.
So that's a good question. So in the finding of fact, the fourth bullet says based on the applicant's explanation. Is that a written explanation? Is there in the application that they submitted?
That's a good comment.
It says that.
Without going back and listening back through the recording of the meeting, or what was maybe discussed at the dais by the applicant in explaining their project. I don't know that anecdotal evidence is necessarily hard and fast evidence. So perhaps this last bullet point, based on the applicant's explanation, that the garage is on the lower space, perhaps that evidence needs to just indicate that based on the photographs, that it looks like a duck, quacks like a duck, and we think it's a garage, so to speak, instead of relying on the explanation, which may have been explained during that original meeting. But without going back and actually pulling that up, I can't say yes or no right here and now. But if we want to be clear on the evidence, we could, I think you could pivot that evidence to say, well, it may have been explained as a garage. It may not have been explained as a garage, but based on what is in those photos, we believe that it to be a garage. We don't have any evidence to the contrary. Perhaps you could go about it that way. Or if you want to be clear on this piece of evidence, perhaps we table this when we go and find that evidence to be more sure or certain.
If it's not considered a garage, does that change anything anyway? I guess that's.
I believe it would.
Yes.
I just have no memory
That's
of
what
that.
I want.
Thinking about that discussion, I have no memory of it being called anything but a garage. I don't have any
I
memory.
agree.
Tonight's the first night I've ever heard anything that wasn't a garage. I don't have any recollection. That's why that line on the evidence, the detached accessory building includes a garage space on the lower level. That's all I ever heard.
So.
Yes. This is the first time I've heard that it wasn't a garage,
But-
and I don't think. So,
That's why I agree with
yes.
the evidence, because that's my memory.
So Gavin, do you have,
So I have one other question. So if the conditional use permit is not approved, the legal use of that space is part of the primary residence.
Yeah, it would be just used as bonus space, whether it's a garage for car parking or for recreational purposes. It's a facility on the lot that would be used by that family in whatever way they wanted to use it.
But it would be considered part of the primary residence for the
The
definition.
primary single family residence.
So, yeah, I think it's unfortunate that it's worded the way it is, but not being a legislative body, being an interpreter of it. I think, Yeah, I think this is laid out well, and to the best of my ability, this is what I'd have to read it as.
Okay,
Mm-hmm.
Heather?
Would it be beneficial to change this last bullet point to say, based on the applicant's original submittal? And that's where I don't know that we can say this is evidence if we're just saying that is an explanation and we don't
Right.
recollect that explanation clearly. I think you would need to maybe change this to say, based on photographic evidence, the detached accessory building includes a garage on the lower level, and just say, look, the photo shows roll-up garage doors. It looks like a duck, quacks like a duck. We believe it to be a garage.
Yes,
No,
I think so.
Maybe,
And we
maybe
already
let
have
me
that.
try this real quick.
In there.
So based on photographic evidence, the detached accessory building includes a garage space on the lower level, which is intended to be used by the primary single-family dwelling.
But I don't think that,
That latter portion may not.
yeah, that doesn't
Drive.
fit. So photographic evidence and the application.
Okay. Okay. Now, the only other thing that I'm kind of thinking about in the back of my mind is whether or not we need to have an interpretation of built entirely over. That phrase built entirely over. We have in this note section, I have not tried to analyze that or apply an interpretation. So it might be beneficial to get the commission's interpretation of that into this document. If the intention is to go ahead and adopt this document as part of our updated notice of decision. That's it's something in my mind I think could be maybe addressed at this point.
Scott, I would say as photographic
Photographic.
evidence
That's what I
shows
would
that
say.
that's entirely over the garage, and there's no way that it's less than or greater than.
So that could be the evidence, but what is our interpretation of the phrase built entirely
The
over?
second level is entirely over.
I think the interpretation is that entirely over references the accessory dwelling unit,
No,
The second-
not the garage.
The second level.
Right, the whole,
Yeah.
No,
the unit.
yeah,
Yes.
the term built entirely over is saying that the accessory dwelling unit is entirely,
above the
Over.
garage.
Mhm.
not that the accessory dwelling unit is over the entire garage.
One more time as I try to
So,
transcribe
so I
this.
mean, you could look at that two ways. You could, if you read that, you might be able to say it's two ways. You could say that the accessory dwelling unit is built entirely over so that the boundaries of the accessory dwelling unit, every square foot of it is over garage. And I think that's the interpretation that makes sense in this sentence. The other way that you might read it is that the accessory dwelling unit is built over an entire garage. And I don't subscribe to that. I don't think that's how it should be interpreted.
Does everybody else subscribe to that same thought process?
The first,
appearance.
how did you first say it?
That it's, where it's built entirely over the footprint. Of the lower portion. Which was the garage.
Of the building.
Would you be able to say that we could interpret it by its plain meaning?
By its what?
By its
Scott?
what?
By its
Yeah.
plain meaning.
Yes.
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 It's what?
Meaning.
Oh, I mean,
Is someone gonna interpret that?
It's just IT, no.
no
apostrophe.
apostrophe.
I'm a millennial.
It's fun to type in front of people. They can do.
Um,
And is it built entirely or built?
Covers the entire footprint of
Built.
the garage.
Is
Start
it
with a
built?
T,
And-
built.
Is it built entirely over?
yep, thank you.
Did you say, Scott, that it covers the entire footprint of the garage building itself?
I think that that's the understanding we did not agree with.
Yeah.
Oh,
Yeah,
okay.
no, so this would be the square footage of the accessory dwelling unit
Is what it says.
is
Match the
over,
square footage.
each square foot is over a garage, over the garage.
They do a good enough job there.
Yep.
Without wordsmithing it more, does that make sense?
That sounds good.
Teresa, there's just one typo. I don't know if you care right now.
Yeah, absolutely.
It's the bottom line of the first page. The second single family dwelling unit. The S,
Bottom of the first page.
yeah, the very bottom, right? No. Oh, you know what? Our first page goes down a little bit. Go down a
Oh,
little
because
bit.
I've added text, sorry. Where am I looking? Sorry.
Oh, it's fixed on this one. It's not fixed on the one we have.
No, it's SL.
Yeah, it's SL instead of, it's S capital I. Where is it?
Oh, yes,
Single-
single family.
Okay, there
dwelling
it is.
unit.
Thank
Sorry,
you.
I knew I saw it on.
It's hiding.
It's not a big deal, but you might as well fix it.
Absolutely. Okay. Not, so if we agree with that interpretation of that phrase. Going down,
Yes.
going down to this sentence, if the detached accessory dwelling unit is built entirely over a detached garage. I don't know that we need to inject that here, with this plain meaning having been, interpreted as the plain meaning. I don't know that we need to change this sentence here.
No, I think.
Okay. Any other thoughts that have come up that we would want to address at this point? So if, for example, we don't have any other concerns and the commission believes that this to be their evidence, their interpretation of the facts that they have been able to glean from the evidence and the conclusion that this accessory dwelling unit should be denied. What could happen is a motion could be placed to adopt these notes and to direct staff to draft an updated notice of decision with these pieces of evidence, facts, interpretations, and consolidate that into our formal written decision, enter that into the record. I probably didn't do a good job of making that a motion that you could repeat, but that being the idea, if we agree with what's on paper here, you could direct staff to put that into a formalized notice of decision, which could then be made a part of the commission's formal written findings on the matter.
Okay. I feel like we're ready to do that. We ready for a motion? If we're ready, I need somebody to make a motion. If we're not, we can keep talking about it.
So I have to ask another question, just as I sit back and sort of think through all of it. So if this were deemed not a garage, or changes to the building were made to make it not a garage, or somehow it was altered, the case was the same, but it was altered that it wasn't entirely over, then it'd be okay.
I think, and I'm not, know if I have this right or not. If you see the one little sketch with the dance studio and the apartment, I'm interpreting this as the applicants want just that apartment to be considered the accessory dwelling, not to include the dance studio.
Yeah.
And I don't think we can pick and choose as a commission to do that.
But aren't you
No,
referencing
no.
the garage?
No, what I'm saying is, I'm just trying to take a step back and from all this in a moment and say, if in a hypothetical case, another application came through. That, well, no, I'm not trying to change anything. I'm trying to make sure we're doing the right thing. If another case came through and it wasn't a garage, because it wasn't built as a garage, or it isn't a garage, and evidence doesn't show that it's a garage, we'd be okay. Because it doesn't, because of this.
I think that the code would be read differently, because if it is not a garage and it's just a dwelling in the backyard, little cabin in the backyard, then we would actually be using, I believe, the sentence above this to say, well, how big is
Right.
this cabin? Is it more
Right.
than 50% of the footprint of the single family
Sure,
dwelling?
but yeah, and so I don't want to go into that whole,
big.
I want to go into that whole thing, but from this sentence. It doesn't ping this sentence.
Because it's not built over a garage
Right.
that is intended to be used by a single family home.
Right. And
So. Go ahead.
and then my last one is if the upper floor, say, had a foundation that extended out another 10 feet over the ground. That wasn't over the garage, that would then trigger the entire leak.
I think we're kind of splitting hairs here, because is it counterlevered, and is it hanging off the end? Is it touching the ground? I think that your interpretation of the plain meaning is that space contained above the garage. I think that's the best you can do, is use the plain meaning of that, built entirely over. If it wasn't built entirely over, and let's say that some of it was built to have space up above, and then maybe there's a staircase that has some living space below, and it's not entirely over the garage. At
Right.
that point, you could maybe use the plain meaning in that sense to say, no, it's not entirely over the garage, and so you're not allowed to have those 1,500 square feet.
So what we have to work with is this.
I understand that. I'm just,
here.
I'm-
Trying to learn.
I'm
Mhm.
purposely asking these questions. So that the applicant has
I know.
ideas that they can consider.
If it's okay, I just have a few thoughts for you, because I understand you're struggling with this, right? Trying to interpret it. And we talk about plain meaning. I don't think it is plain. There's a couple of things I like to say. If you say Nan Isaacson is a member of the Planning Commission, she is in attendance this evening, right? The she is referring to Nan Isaacson. I would submit that the entire structure part of that is referencing back to the unit, which you guys have just struggled to define. Where is the unit? Do we say it's entirely over that garage? Does it hang over, right? You're trying to define the limits of that unit. You're not a building commission, right? Like, this has been approved by the building commission and inspected. You're not worried as much about the limits of the structure. You're trying to look at the unit, right? That's what the conditional use permit is for. I would say you could easily say the plain meaning is the detached accessory dwelling unit is the entire structure, is what that's referring to, for one thing. I know you said you can't pick and choose what portions to look at. Former dance studio. I mean, this isn't a dance studio. It is a finished space that is accessible to the primary unit. We're not asking you to pick and choose on that. I mean, it's not like it's just gonna be. It's not gonna vanish into thin air. It's there, it's approved for use for the primary structure. It is completely separate. We've showed you by 2 doors from the apartment. So we're just gonna talk about the apartment. So I just don't want you to say can't pick and choose. We're not asking you to ignore something else and say that's not part of it. However, when you're looking at one of these that is inside an internal structure, you don't look at the whole structure. You look at the unit. And that's all I'm asking you to do. Is I believe the plain meaning of this is saying that the unit and the structure of that unit can't exceed 1,500 square feet, just that. How? Because if you interpreted it differently and you said, okay, the whole entire structure now, which however big that ends up being for anybody, can't exceed 1,500 square feet, that's more limited than the 1,000 square feet, which it says above, which it clearly is trying to make it less limited, right? You're trying to say, oh, in fact, you can make it a little bigger if it's entirely over garage. But if you include the garage square footage and anything else, that limits it even further. In addition, I would just say that if you interpret it that way and conditional use permits in North Logan die at the sale of a property, what you're going to be flooded with is a whole lot of properties that have been previously approved as conditional use permits in this city that now will be ineligible, meaning that when that person sells that property, you've now, for us, if you find this, it diminishes our property value. We cannot sell this property to somebody else and say, this is an investment property. You could rent this out to somebody else. That's taken away. Our property rights are taken away then. And we've lost a lot of money in the process in doing that. And so will many other homeowners in North Logan if you find this way. However, if you take the plain meaning, which I believe is plain, and I think you can see that too, the structure is referring to the unit, not the entire building. I know this is a unique case, but I think there are more than one interpretation. I think it's simple to come to that. And I would just encourage you to really think that through. Do you have any questions for me?
I don't think so. Thank you. I think that I think it's the whole accessory dwelling. I don't change.
So if
I'm
we
sorry.
want to, based on what was just mentioned here, this bullet point here at the top of the screen, if we want to talk about entire structure and our interpretation of entire structure, the way that if we move forward with it as it's written, this is how it would be interpreted. It says, lastly, we interpret the term entire structure by its plain meaning and as evidenced by the additional use of the defined term gross area in the same sentence. Gross area is defined in the code as the sum of all areas on all floors of a building, including within the outside faces of its exterior walls, including any garage space with stairwells counted only once, not including basement space. So if we go back up to this sentence, this term gross area is contained within the same sentence as the term entire structure. So that's how, if you adopt this as it's drafted, that's how we've portrayed that interpretation. Now that may differ. If you agree with Ms. Hopkins' determination, perhaps entire structure could be defined as just the accessory dwelling unit, the walls of that unit that are designated for dwelling space. I don't know if anybody on the commission feels that is how it should be interpreted.
Anybody feels that? I think that I sense that everybody's okay with how we've got it written here.
We need that.
Can we have a motion? Are you ready to move on?
Yeah.
Do you want to table this?
No.
I hope not.
I move that we instruct staff to write an updated denial of the requested conditional use permit, the detached accessory dwelling, and as the major contents of that being this.
You would adopt
I would
this
adopt
note
the
section.
evidence, interpretation of law, code finding, facts, and conclusions.
Okay, do we have a second?
I second that.
Okay, Gavin has moved and Heron has seconded that we adopt. That we, I say this now.
That we accept that.
That we will accept this new evidence interpretation of the law, code findings of the facts and conclusions. With these statements that we still deny the permit to this building. Is that good enough?
Direct staff to include.
Direct staff to do that.
And then let's just make sure we're adopting these
All these
points
things,
of evidence, these interpretations of law,
yes,
these findings of fact. and
everything up
conclusions.
here that we've done
The electronic version,
up there,
not the print.
not the ones we have,
Correct.
the ones up here,
Yeah,
which are pretty close to the ones we have.
I'm gonna make one quick. I'm just gonna take out this lastly because we added one bullet point below. Okay. Would we like to restate the motion? Do we feel like we're all on the same page? That as it's been adjusted electronically during tonight's meeting, this version of the document is what is being adopted and staff is being instructed to use this document in drafting an updated notice of decision.
Yes,
Correct.
That's my intent from the motion.
That's, the motion has been seconded. We need to vote on it. All in favor?
I,
Aye. Any opposed? All right.
Okay.
Thank you.
This is hard.
Absolutely difficult. Nothing's easy.
That gross.
No,
area.
it's not. Okay, we'll move on. I gotta find my notes. Let's move on to item number 3. Thank you. Work session regarding potential amendments to the city's conditional use permit and accessory. Oh, we just did that. No, that's where we're at.
No, that's
My
correct.
brain's fried. Okay, work session regarding that. Scott?
Absolutely. Okay, I know we've done a lot of mental acrobatics tonight, and this next proposal it's a work session. Now, I haven't provided this to you beforehand because I'm still working on it. I'm still drafting it, and I would like to have a little bit of discussion. I don't expect you guys to have this in your mind or even be able to follow along with any sort of study time because there wasn't any. What I do want to perhaps communicate in this initial work session, this initial discussion, is that over the past several months, we as a commission have reviewed a couple of things. We've reviewed short-term rentals in a roundabout way, not directly because it wasn't a formal request that came before the planning commission, but it has been a point of discussion in past decisions that have kind of muddied the waters, clouded the decision. We've talked about accessory dwelling units, both internal or attached and detached. And we've had quite a bit of confusion on both of those topics. And so I have started drafting some proposed text amendments to hopefully clear up some of these things. In the background, something that the commission hasn't been involved in is some code enforcement files that have been opened at the city for short-term rentals. A couple of larger properties that have had complaints from members of the community and that we've been working on as staff just through the administrative code enforcement process. And so I have maybe some more background or I guess exposure to some of the issues that have arisen on these particular land uses that I think we could maybe make some improvements. We've had some members of the public show some concerns. We have one here tonight. We appreciate Dr. Olson being here to give us some feedback. And I think there's some definite room for improvement. I think we can all agree that there's some clarity that could be had and is actually very much needed. So what I've started doing, I've wrapped in some adjustments, some initial thoughts on conditional use permits, accessory dwelling units, both attached and detached, for conditional use permit process, or noticing, and the noticing is a bigger topic. As a side note, the legislature has actually taken steps to pass a bill intended to clarify noticing requirements, standardize them, hopefully across the state for the state, counties, municipalities, special service districts. Everybody is supposed to be using a very standardized noticing process going forward, which I think is great. Our code has multiple sections that speak to noticing and how and when and what we do for public noticing for different types of applications. And the state's language actually went live 2 days ago. And so our code, our noticing is actually out of date and we actually just need to follow state code because ours is not compliant. So simply, hopefully this is the easiest part of this proposal is that we'll strike all of our noticing that is unique to North Logan. And we'll just say that we're going to follow the state noticing requirements. Keep that as simple as possible. So that's part of this proposal. The other part is we need to very clearly separate attached and detached accessory dwelling units. I think we all agree that there was past legislation that attempted to separate them, didn't do a great job of doing so, as evidenced in some of the standards in our code and the sections in our code. But there's also some topics as far as parking. It's not clear where parking should be. I mean, there are some pieces of language that talk to spaces being made available, but it doesn't direct that those spaces should always be used for specific purposes. And so there's that aspect. There's an occupancy question with short-term rentals that really isn't defined anywhere in our code what the occupancy should be. And I think we should tie that to the capacity of the facility, whether we're talking about number of bedrooms, actual parking spaces that are on site, a few of those considerations. So that's the intent. It'll be some mental acrobatics to get these things separated and clarified, but I've started putting pen to paper. This proposal that you have in front of me, the way that I try to address or attempt to go through this process is to pull all of the language out of the code that I think may be applicable, just copy paste it into a big document that shows the context, and then kind of read through it and find areas that we need to fix, and then try to back check to make sure as we make adjustments that we're not creating more issues elsewhere in the code. We're getting late tonight, and I don't want to stress people's minds any further. But what we'll do is I'll send this out as it's currently drafted, as long as you guys understand it's a rough draft and that there's more that needs to be done. I have gotten through, I believe, page 36, 37. You'll see that's kind of where the red lines stop. And I'll need to continue going through
38.
38. Yeah, 38. So there's more that I have in the back of my mind of adjustments that we need to make. And we'll obviously be talking about this at a future work session, but if you'd like to start reading through it, feel free. I hesitate to tell you to jump into it with as much detail because I know that there's going to be adjustments even in these first few pages that I need to make. But if you want to start kind of wrapping your head around the sections that are at issue, maybe start familiarizing yourself with the language that exists, then maybe we can come back with maybe a little bit more of an educated discussion on how we start cleaning up these issues. Because I'm sure this won't be the first time that we'll have to apply this code. And so it would be nice to get it cleaned up and fixed. One thing I think that is important is I've never sat through a planning commission meeting where we are legally analyzing code. This is unique, and I think this new case law has established a precedent that is extremely challenging for a body of laypersons to administer. We'll see how that plays out in the future, as far as having remanded decisions come back for very specific interpretations and findings of fact. But I think I hope that gives you at least an overview of what this text amendment, this file number ZTA 2023-03 will achieve or attempt to achieve. Trying to clean up those sections of conditional use permits, accessory dwelling units, noticing process of reviewing and approving or denying a conditional use permit. Do you guys have any appetite to jump into this in any great detail tonight? I'm happy to do it if you are.
I
I
appreciate
think it might be helpful to get your eyeballs on.
We should have a chance to look through it a little bit
Yeah.
more.
Just
Are you
know,
wanting us just to look at where you've highlighted at this point? Because
maybe
everything
just-
else is staying, right?
yeah, don't spend too much time getting into the nitty gritty, but at least you'll understand what sections of code I think need to be addressed. The red lines still show all the existing language, so you can read it with the red lines there to see what exists now and perhaps where there's some inconsistencies. But then we can come back. I hope the commission understands when I schedule work sessions, I don't anticipate you guys to be fully up to speed on these things, especially the first work session we have on a topic. I usually don't provide it to you ahead of time because I know we're going to walk through it together. So there's no expectation that you have these things fully comprehended before you come to the meeting.
Or even after.
So just a question on process. So we go through work sessions on this and talk through it, and then we'll get to a final draft that then comes here for a potential recommendation to the
Public hearing first.
Okay,
Yep, get the public's input on it because these are legislative decisions. We are changing the law. And that requires that we go through a public process. We want the public's input, it'll be available for the public if they want to read through it, provide us with suggestions as well. Once we have the public comments, either submitted beforehand electronically or given to us here in the meeting itself during the public hearing, you can use that information to further craft and adjust the language. Or if you think that the language is where it needs to be, then you can make a motion on a recommendation to the city council. So the city council, just so you know, on these legislative types of decisions, they are the approving body.
Scott, now the red lines, are those changes or are those that are there now and need to be changed? And the highlights?
Yeah, so a red line document, traditionally, a red text with strike through means we're deleting it.
Okay,
Blue underlined means we're adding.
okay,
And anything that is in green means we have cut it from one place and pasted it into another place. Okay, the headers, the section headers are blue and underlined because that's how they are formatted in our code. So when you paste it over, that's the formatting that is applied. So the headers, don't get those confused as proposed additions. Okay. A couple of things, because this is quick. We've, I think, understood through this process that a public hearing for an administrative item may not be the best idea as far as inviting public clamor into an administrative decision where technically we're just reviewing for compliance. And then for a conditional use permit, for example, we're looking at compliance to the code. Does it meet the standards? But also, what conditions do we need to add to a potential approval to mitigate reasonably anticipated impacts? But other than that, the public comment on an administrative decision really can't change the outcome because we are charged and tasked with just reviewing the application to verify if it meets the standards as they're already drafted in our code. So one of the proposals in here is we would not do a public hearing and notice the neighbors to bring, the neighbors in for comment on a decision where they don't technically have a say in the outcome. The code is what determines whether it can be approved or not. So that is one change that I think is needed. Could have eliminated some of that clamor and maybe had more of a clear discussion. So I think that's an outcome I'd like to propose as part of this text amendment. Okay. Any other questions on what this file ZTA 2023-03 intends to achieve? Okay.
But you'll put it on for next meeting too.
Yep, we'll have it on for our next meeting. I'll continue working on it in the meantime. You can use this as what we've achieved as staff so far. I'll keep working on it and hopefully I'll get another draft out to you ahead of the next meeting. But yeah, so don't dig too deep, but maybe start reading through it, wrap your head around the sections that are applicable and maybe some ideas you might want to see changed as we work through it.
It would be nice. Do you typically include the definition sections in here because there may be some definitions that need to be added, strike, modified?
So this particular proposal, I have added the entire definition section because there's a few that we'll be adjusting. Other proposals, I might add a snippet of the definition section where we may be making an adjustment, but I'll try to truncate it because we're not changing any of the rest of the section. So this one, yes,
Yeah, I
others
found it.
maybe not.
Yeah, we're good.
That's where.
Yep.
This one, which was the concluding.
Yeah.
Moving on to number 4. Are you ready? Scott? Recap some of the lessons you've learned.
We keep postponing this.
Yeah.
We're going to let you have time to tell us this though tonight.
Yeah, I'll keep this brief. It really isn't that critical that we have this discussion, but if you'd like to, poke through some of the notes that I took at this conference, feel free. One thing I think is a good takeaway and would probably benefit to have you guys take a look at is a product put together by the National Planning Association, the American Planning Association. They put together a trend report. I didn't even know this existed until I sat through a couple of sessions, but what the American Planning Association is trying to do for planners throughout the country is they're trying to take the enormous amount of change that is happening at an accelerated rate and trying to distill that down to something that is actually digestible. And this trend report is they're looking at everything that is trending and they're trying to kind of distill that down to a couple of buckets. And they've kind of brought it down to trends that we should be acting on right now, trends that are on the horizon we think we should start preparing for, and then some trends that we're learning about, kind of watching to see what happens. Are they going to continue? Are they going to fizzle out? let me zoom in on this real quick, and you guys can go and take a look and read this when you get another minute, but some of the act now trends, top of the list, climate policies, funding and action, the digital era. I think included in that digital era is AI, artificial intelligence, how some of these digital and technological advances are rapidly changing our climate. Federal funding, whether it's available or not available, and how that is changing over time. Programs that we used to be able to count on that we can't count on going forward, or new programs that may be rolling out that didn't exist before. Gender expansiveness, policies on health, the housing crisis. I think the housing crisis is, everywhere, but we've certainly felt the housing crisis here locally. Social media, equitable transportation, younger generations, and some of the social challenges that they're facing. But so this was interesting to me as they said, hey, here's a tool for planners to use, and just trying to understand what's going on in the broader picture. I thought it was a unique product put on by this association who I hold my accreditation through, my American Institute of Certified Planners. The APA is our body, and this is one of the things that they provide to planners throughout the nation. So if you want to get a really big picture idea of what's happening nationally, globally, from a planning perspective and what we're looking at long term, they don't always distill all the way down to the local level when we're looking at a subdivision plat or, some of these policies, but some of them do. As we're looking at climate, for example, maybe one of the things we're trying to consider is how do we reduce the number of vehicle miles traveled? Kind of distills down to active transportation. How do we get people on foot instead of in cars? Those are small decisions that we can make that may actually change the bigger picture, even if it's just on a minute level. So anyways, this is available. It's in the folder there if you want to read it, but the APA holds it under a bigger umbrella that they call Foresight. They've branded this product as part of their Foresight. So if you want to Google American Planning Association Foresight, this is one of the products under that branded bucket. I thought it was really interesting. I thought it would be helpful for me as I'm trying to keep my head on the big picture. So that I thought it was interesting, a key takeaway. There's a lot more in the notes section if you want to read through some of those notes, but I thought this was maybe something worth sharing with the Planning Commission. Anyways, there's a couple of photos in there. This year's conference was in Philadelphia, so I felt like it was almost like a trek to what do you call it? I'm trying to think of the word, but anyways, this is Independence Hall. We have a lot of historic, significance here with some of our founding fathers, and our founding documents were signed in this very building. So I thought that was interesting to be able to go see Liberty Bell, some of the old cobblestones that are still original in Philadelphia from the original streets that were put in. One thing is Benjamin Franklin's grave there. This was, I thought, cool. This is the oldest continuously inhabited residential street in the United States. This is called Elfress Alley, and it is higher density than anything we have in North Logan City, believe it or not. This was before vehicles. Everybody had to walk everywhere, so there wasn't expansionism and sprawl, which we, post-war have had sprawl that we're all trying to find a way to reel back in and get back to a more European development model. So anyways, I thought it was kind of cool. Thought I'd share that with you real quick.
So you tied up your hands.
Cool old buildings.
Yeah.
Anyways, that, I guess key takeaways, short and sweet.
That's it. Loved it.
Yeah. I'll keep
All
going.
right, thanks,
Keep going.
Scott.
Yep.
Hey, any other staff business or discussion?
Yes, so one thing that is on the horizon is there's a mid-year cash summit coming up. This is June 15th, 2023 from 5:30 until 7:30. It's kind of a local gathering of planners, staff members, planning commissioners, city councilors, mayors, elected, appointed officials. You're welcome to attend. It's kind of a lunch summit, or sorry, a dinner summit. There is a small registration fee, which the city would pay for if you'd like to attend. But they're looking to talk about zoning more on a regional scale, some of the politics of zoning and housing, you're talking about a mix of housing. A few of those topics will be addressed. So if you'd like to go, let me know, shoot me an email and I'll get you registered. But it is June 15th from 5:30 until 7:30. Okay, that's I think the only piece of business I needed to bring up.
Okay. Thank you. Our next meeting is May 18th. Can we have a motion to adjourn?
Madam Chairman, I so move. I mean,
A motion is made. Is it seconded?
Second.
Okay, it's been moved and seconded, moved by Karen, seconded by Heather to adjourn this meeting. Thank you. All in favor?